jury will not be sequestered.
I'm Brian Buckmeyer, along with Terry Austin.
In the Weinstein case, fellow silence breakers and any...
Jury selection is moving along
Well,
here.
I'll read the verdict, says njlawyer. Thanks for joining us.
We don't tend to see it as raw as this.
Good evening and welcome.
How are we doing?
Good. Hey, we got a call about a male hitting a female and the two of them getting in this vehicle and taking off.
So I don't want to try and defend myself by saying anything here, but I pushed her away. She gets really worked up, and when she does, she swings, and she had her cell phone in her hand, so I was just trying to push her away.
Welcome back to Law and Crimes for the Record. My name is Bob Bianchi. If you take it at 3 o'clock, obviously you saw Brian Laundrie there in that clip, but before we get that, let me tell you, we got a lot on the plate today. The trial death of Ahmaud Arbery. We are still looking for jury selection in that case. Going to take a long time. The sentencing of Mohammed Noor. This may affect the Derek Chauvin case. We'll talk a little bit about that. Nicholas Cruz, the Parkland shooter, he's pled guilty. So we're going to definitely be talking about that. Jury selection still going on with Markeith Loyd. But let's get back to Brian Laundrie for a minute. Major development yesterday. Human remains were found in an area of the swamp where Brian Laundrie's car was last seen. They found a backpack and papers belonging to Brian Laundrie at that location. Apparently, water had receded in that particular area, exposing those human remains. The FBI and state and local law enforcement officers are now on that scene, and they're certainly going to be processing it. And the medical examiner indicates that they should have an identification within 1 or 2 days. So let's go to our very own Joseph Scott Morgan, a forensic death investigator, who could tell us a little bit more about the significance of this major development.
You start talking about items. What are those items? Could it be clothing, backpack? Could it be bones? You never know. And then the fact that they had the parents out there, maybe it was a specific item they wanted them to physically identify. Say, does this belong to your son? Have you ever seen him with this item in his hand?
Wait a second.
And of course, they're not going to bring the family over if they have skeletal remains or, remains in any other condition to see the body there. That's Hollywood myth. That doesn't happen. They're going to keep them away. This is a closed crime scene at this point. The other thing that you have to consider here is the Emmy is there. And I worked for the Emmy for a long time in Atlanta and with the coroner's office just outside of Atlanta, outside of New Orleans, started my career. I can tell you this, we never showed up unless we were invited, all right? And for us to be invited means that you found human remains. And it's a long process. People, listen, please listen to me. Folks have to be patient with this because this is not even like Gabby's case, because if these are his remains and they've been down for, say, for instance, as long as Gabby's were or approximating that period of time, these remains are going to be significantly decomposed. It's in a harsh environment. It's going to take a while to put these pieces together. And thirdly, they brought cadaver dog out.
Katherine, how are you, Bob Bianchi?
According to reports. So what that would mean to me, and this happens, and I'm sorry,
I'm doing great, thanks. We'll be with you in a second,
okay? Bear with me. If someone finds remains, okay, maybe you find the central portion of a skeleton, let's say spine or ribs and this sort of thing. What generally happens is that over a period of time, due to animal activity, scavenger activity, remains become disarticulated. And animals will take these remains and they will wander off with them. Generally, they don't go very, very far, but you have scattered remains that are all around. And you have to kind of connect this, and let me explain why. The dogs would go out and hit on any other remain that might be out there. You know, just think of a wagon wheel hub and the spokes going out from it. They'd have to take this and kind of bring it back to that central collection point. Do you remember they showed that tent being set up out there today? That's going to probably be the central collection point where they're going to, gather everything. Now, they're not going to try, if it is a skeleton, they're not going to try to re-articulate the skeleton out there. This is going to go back to the lab. There's a high probability it could go to the CA Pound lab at University of Florida. It's a human remains identification location. But at any rate, you have very little evidence to go on. You don't know what brought about that's what makes skeletal remains so difficult. You don't know what brought about the death. So you have to collect everything that is there, consolidate it, examine it in a controlled environment, and it takes days, sometimes weeks to make these kinds of determinations. And sometimes you're not even going to know because all you have left is a skeleton. If you don't have a skull that has a bullet hole in it, or if you don't have soft tissue where you can appreciate strangulation or hanging or something like that, sometimes, the forensic community is just left to say, best guess here is undetermined. We can't come up with anything solid. And I know that's going to leave a lot of people dissatisfied, but I'm not saying that's what's going to happen, but just prepare yourself for that because it does happen on occasion.
Katherine Lizardo is a trial attorney, and Kaysia Earley is a criminal defense attorney. Katherine, let me throw it to you first. What do you make of these developments? I found it interesting that at least it was reported that the medical examiner says they can have an ID within 1 or 2 days. And sometimes when the body is in that condition, making a positive identification can be very difficult. Is it your suspicion that they pretty much have preliminarily believed that this is Brian Laundrie?
I think there is some suspicion that this is Brian Laundrie, right? But because we have to think about the personal belongings that they found his notebook and his backpack there. And also, I find it very interesting that his parents wanted to go there that morning. You know, that reserve is a very difficult terrain, and water has receded from it. That's why they were able to look for Brian Laundrie if that is his remains. And so the medical examiners are there to make sure that that's him. And I think it will take some time because if that is him, it takes some time to, with his remains being scattered by animals. So that's something that might be what we're looking at here. Looking at that picture, as you can see, it's a very harsh terrain. So let's see what the medical examiner will find out, and it might take time.
Yeah, Kaysia, I mean, obviously it would be disappointing. I mean, we would want to know the full story as best as we could, but identification is issue number one, and then cause and manner of death would be number two. But do you have any insights in your thoughts as to whether or not this is going to be Brian Laundrie?
I absolutely believe it is him. I stated before, after the time went by, he kind of left abruptly. There was no plan. Typically, when you go hiking, you have all of your supplies, you have everything that you need. But when Brian Laundrie left after he was identified as a person of interest, it's just like he disappeared. And doing so, I believe he wasn't prepared, and he could have possibly, there's a host of reasons as to how he could have passed away. He could have died of dehydration and was disoriented. But bottom line, his belongings were there. I'm pretty confident that is his remains will be identified. And I do believe that the parents, I agree with my colleague, had an idea. Look, they let him right at the place where he typically camps. And usually if you're an avid hiker or camper, you typically revisit the places that you have gone to in the past. So I believe they kind of knew that it was coming to a conclusion, and they wanted to help as much as possible to possibly avoid any obstruction of justice charges.
Yeah. Excellent analysis by both of you. Well, let's listen to a little bit more of our friend Joseph Scott Morgan as he breaks this down.
The thing about, being down there in the swamps like that is that it's so harsh. The soil and the water, everything is so very acidic down there that remains break down very, very quickly. It's like a huge, just imagine a big, how, I don't know if your parents had one of these when you're growing up, a gardening what's it called? Composting pit where you rotate things. Imagine that on steroids in the swamp, and things just break down really, really quickly. And then you're absolutely right about the animal predation. The worst animals you have to worry about in the swamp are raccoons and possums. People don't think about that, but those little animals like that, they drag things away, and they just kind of nip at the sides. And squirrels will actually get involved too. I know people find that hard to believe. They love like the little bones and fingers and whatnot. So yeah, it's amazing. And I know, sorry. All these animals, people think they're all cute little vegetarians. They're omnivores, many of them. So it's a odd thing. But yeah, it'll be interesting. The trick is finding that skull. That's going to be the biggest problem. And the thing with skulls is that dogs love them. And if a dog came along, that skull could be anywhere. They treat them they like to feast on them, but they also like to play with them. They treat them like a ball. It's the damnedest thing you've ever seen. It really is. It's amazing. So I don't know if there's any soft tissue left. And I don't know that this guy is a handgun owner, so for me, he could have OD'd or he could have hung himself, or I guess he could have cut his throat or something like that. But, very few people actually do that. Very few people actually cut their wrist or cut their throat. Hanging is like the second most frequent cause of death that we come across in suicides. And then drugs are lagging behind, guns being number one. But it'll be interesting to see if they find a rope hanging from a tree out there and he fell out of it. Yeah, I think that's certainly possible. Remember, we'll be able to do, not me, they will be able to do DNA sampling, potentially on the bone, or any other tissue that's left behind. It all depends on how intact the sample will be. And we've certainly got a parental sample. I would suspect that they've probably already done a buccal mucosal swab on the parents. At some point in time, I could have sworn I saw them going into their residence with DNA swab kits. So that's not too far off the radar, I would think. Now, as to whether or not it'll turn around really quickly, I have no idea, because we don't know what condition the so-called remains are in. But if they're saying that there are human remains there, that's significant. That's the reason they called the medical examiner out earlier today, because they found something that they believed to be human remains. The ME came out and confirmed it. Now they'll just move on forward with the investigation from here.
Hey, see, if it is Brian Laundrie's remains, where does the case go from here? Keeping in mind that he's been charged federally for improper use of Ms. Petito's credit card and is a person of interest in a homicide case. Does that just end the matter, or do you suspect that they're going to try to do something else to give the family and the public more information?
Well, it depends. Again, I do believe that there's still an ongoing investigation to see how much the parents knew. But obviously, the criminal charges against the defendant dies with the defendant. So you can't charge that person. And as much as the parents would like to have closure and seek justice, this may be the only closure, unfortunately, that they get. I mean, we all kind of suspected that he was involved when she was disappeared. And it was only confirmed after the report came out that she died by strangulation. So unfortunately, if it is determined that this is identified as his body, this case remains closed as to Brian Laundrie. Now, his parent, that's another story.
Katherine, there's a process in the grand jury. I never really utilized it, but I did have a case one time where the family wanted to know with a serial murderer whether or not another body that was unearthed was connected to him, where the grand jury can not necessarily convene for purposes of issuing an indictment, but an investigative report. Now, I'm not sure if we have that down there in Florida or not, but is that an avenue prosecutors may look at? In other words, do you think prosecutors want to give the family and the public more, and if they have the tools to do it, they'll do it?
Yes, I agree. I think they will. We don't have that investigative report right now, and that's something that will come up hopefully later on. But something to think about is that Brian Laundrie was just a person of interest. He's the primary suspect. So my colleague said that, yes, if that is his remain, that case against him would probably die and he won't. And then that's it for Laundrie. But the family would still want closure, right? And so we are obligated to still look for the killer of Petito. And I hope that those investigative reports will come to light so that the family can have closure, because we have to think of the human element here as well.
Yeah, definitely. It's no question about it. Well, anyway, Nicholas Cruz, Parkland shooting infamy, has pled guilty. We're going to be talking about that on the other end and some really strange developments with respect to that plea. So stay with us.
I am very sorry for what I did, and I have to live with it every day. And that if I were to get a second chance, I will do everything in my power to try to help others. And I am doing this for you, and I do not care if you do not believe me. And I love you. And I know you don't believe me, but I have to live with this every day, and it brings me nightmares, and I can't live with myself sometimes, but I try to push through because I know that's what you guys would want me to do. I hate drugs, and I believe this country would do better everyone would stop smoking marijuana and doing all these drugs and causing racism and violence out in the streets. I'm sorry, and I can't even watch TV anymore. And I'm trying my best to maintain my composure, and I just want you to know I'm really sorry. And I hope you give me a chance to try to help others. If I believe it's your decision to decide where I go and whether I live or die. Not the jury's. I believe it's your decision. I'm sorry.
All right, statements by Nicholas Cruz, who was accused of and now has pled guilty to the murder of 17 people at the Marjorie Stoneman Douglas High School in February of 2018. This case is going to be going directly to the penalty phase. Kaysia, you're down in that neck of the woods. I understand that you may have been on another matter, but were able to witness some of what was going on there. What did you see?
Absolutely. So after he took his plea, when the court broke, you could see the victims and the families of the victims coming out, and there was mixed emotions. Some felt a sense of closure. They expressed that to other reporters that were standing outside of the courtroom, and others were adamant that they wanted the death penalty. They felt that his apology wasn't sincere, especially at the portion where he said, I don't care if you don't believe me. They felt that this was his last plea to pretty much save his life. But one of the parents believed that this is his way of accepting responsibility, and that he is about to see that his actions or what his actions resulted in. And it's just so many lives were destroyed from this horrific incident, and the parents just want closure. But you're absolutely right. The penalty phase is next.
Yeah, Katherine, what do you think was the tactical decision by the defense lawyers to not go through the guilt phase of the trial, but move directly to the penalty phase?
I think the tactical decision there is not to have the families relive the scenario, right? And also not to have Nicholas Cruz have to relive that. This is a very emotional case for everyone. There are no winners or losers here at the end of the day. So it's best for everyone to have him plead guilty and then move now to the penalty phase. And it's interesting that he's saying, I'm sorry for what I did, and that I choose you, the family, to decide my fate, whether I'm going to life in prison or death penalty. Now, the law here is that the jury are the ones who are to decide his fate, not the family, not the judge, but the jury. And he understands that. Earlier, the prosecutors raised that issue, possibly in case that there's an appeal that he did not understand his plea, but they clarified that he understands what the law is, and that it is his personal preference to have the family make that decision. And they will provide victim impact statements at the penalty phase, right? So that will be considered as well.
Yeah, interesting about this case, and I really like this by the prosecutor. It always bothered me when I was making these calls that he refused to plead this case for anything other than what it was. So he basically was like, you either go to trial or you plead guilty. So he forced their hand on that. But interesting, you should bring this up, Katherine, the segue about what Nicholas Cruz said about who he wants to decide his fate. We actually have a clip on that. Let's take a listen.
Sure. And that is when the defendant was exercising allocution. He said at the very end that he believed that you were in charge of his sentence and not the jury. So
I'm not sure if he was talking about. I'm not exactly sure who he was talking about. I don't know if he meant you meaning me or you meaning the victims.
We can clarify so that he does understand that in Florida, it is going to be a jury that determines his sentence as to counts 1 through 17, and not this court, so that we don't have an issue later on appeal or a 3.850 or a 3.851 saying that he misunderstood.
Sure. Mr. Cruz, I'm not sure who you were. I'm not sure if you were talking to me or the victims' families when you said you. But you do understand the state of the law. I went over that with you.
Yes, I do.
And so you know that it's neither me nor the victims' families that are going to be in charge of imposing the death penalty. I don't know if you meant, the way I took it was you meant that they could ask the state to waive it. No, that's not what you meant. Well, why don't you just tell me what you meant?
What I meant was that I believe they should have the right to choose the victims themselves on whether I should take life or death.
So in other words, you're urging the victims to encourage the state to waive it and sentence you to life.
Judge, may I interject?
Sure.
I think what Mr. Cruz was saying was that ultimately in his heart he believes it should be the victims' families that make the decision about life or death. We have, however, explained to Mr. Cruz that it will in fact be the jury that will make that decision after the presentation of evidence of aggravators and mitigators in phase 2. Okay. This, I believe, is just his personal belief.
I understand.
It is in conflict with the law, but he understands the law.
Okay.
Yeah,
Mr. Cruz, is that correct?
Yes.
So if you were the legislature, you would leave it up to the victims to decide what penalty to impose, but you understand that's not the state of the law in Florida.
Yes, I understand that.
You understand it's going to be up to the jury.
I understand that.
Okay.
You see, interesting, and the judge buttoned that up, and the lawyers buttoned that up nice, as well as the defense attorneys, because I'm sure the numbers of the code that they were referring to deals with ineffective assistance of counsel and whether or not he had received proper advice. So that was a very necessary part that that they accomplished on the record. Now, let's get to the substance of what Mr. Cruz is saying, Kaysia. Some people may ask, why not let the victims decide the fate of a defendant like this as opposed to a jury? Can you give us an explanation as to why our system operates that way?
Of course, because the victims, they're too invested. Obviously, they would want the most extreme because they lost a loved one or they was affected by being a victim. And with a jury, we're always looking for a fair and impartial jury that is willing to put aside any biases or personal opinions and examine the facts and evidence as presented. So clearly, victims won't be able to disassociate themselves from what occurred because they're too, again, personally affected and invested in what was committed. So the best way to do this, the fair and just way, is to utilize independent jurors to make a fair and impartial decision based on the law.
Okay, Katherine, since we're going just to a penalty phase, essentially what happens is that each state that has the death penalty has its aggravating and mitigating factors that the jury all have to come into agreement with beyond a reasonable doubt in order to give the death penalty here. Given the gravity of this particular situation, the number of people that were harmed, the vulnerability, I'm thinking of just aggravating factors that I know off the top of my head. As a defense lawyer, where I know your main goal is keep them alive, is that anywhere near possible in a case like this?
Well, that is certainly what his team will try to do. I used to be a defense counsel before I became a plaintiff's attorney, so I see both sides here. So during the penalty phase, they will try to ask for life in prison instead of death penalty. That would be a win for the defense, right? And it's interesting that during his statement, he was saying that I hate drugs, I hate marijuana, and I wonder, are they going to raise that as a defense or mitigating factors during the phase 2 penalty phase that he was under those? Now, I have no information if he was or was not, but maybe that's something that they're trying to set up at this stage as well.
KC, you can't help but look at him and his very demure and hunched over look that he has to even think that this is the person that did this carnage. So the jury will see that. They may hear some things about drugs. They may hear some things about mental health issues that he had, because obviously anybody would do this. I'd always said this as a homicide prosecutor, you'd have to be mentally ill to do something like that. Are those the kind of mitigating factors that you think can possibly overcome all the aggravating factors in this case?
They can be utilized as consideration. I guess the most important mitigation would be the fact that he accepted responsibility with the plea. That is also considered a mitigating factor, because had he allowed this trial to go forward, we're all sure that this would have ended in a conviction. We have to also know that Nicholas Cruz was not declared incompetent to proceed. So any report that would address his mental illness, although it may be a mitigating factor, it's just one more on his report. But I do believe the fact that he is remorseful, he is taking responsibility, he seems to be accepting any punishment that may come his way, albeit the death penalty or a life sentence. this is something that the jury can, in fact, take into consideration because, again, they're not only judging what he did, they're judging whether or not he has accepted the potential punishment and has somewhat become rehabilitated.
Yeah, that idea of accepting responsibility, I think, is a big factor. And they'll probably have an expert to talk, what they call an aging out expert, as to how long it is and how harsh it is to be, serving a life without parole sentence. We'll see where we go with that. Great commentary, guys. Ahmaud Arbery, there's a lot going on with that case, including jury selection and other developments that are occurring. We're going to be talking about that on the other end of the break, so please stay with us.
Well, we expect that this case is going to play out like we have been talking about for so long now, that this is a well-intentioned young man and father who were simply trying to do the best that they could, along with the other members of their neighborhood, to control the crime, to understand it, and to get the police involved as quickly as possible. And in doing so, thought that they had an opportunity to keep an eye on the number one suspect that they believed was doing the thefts in the neighborhood and that they believed was dangerous. And in doing that, in trying to keep an eye on him, in trying to engage him in conversation, in trying to talk with him and say, can you just tell us what's going on back there? Or what's happening? Or what are you doing here? In that conversation, he responded with nothing. No explanation, no anything, until the point that he decided that his way out of this detention was to attack Travis, who then had no choice but to try to keep control of his firearm and ultimately pull the trigger.
All right, so that is Jason Sheffield. He is the attorney for Travis McMichael, the alleged actual shooter in this particular case. That was an interview done with our very own Linda Kenny Bodden. And all the defendants are facing malice, murder, and conspiracy and attempt charges and multiple other charges. They're in day 3 of jury selection. 15 jurors so far have been qualified. The magic number appears to be 64 jurors that they're looking for before they start using the peremptory challenges. Kaysia, you listened to the defense attorney for Travis McMichael. What are your thoughts about his statements that he made with regard to the shooting of an unarmed man?
I just hope that that's not his opening statement because it just doesn't make any sense whatsoever. He just stated that they were trying to engage in a conversation with a dangerous man. You don't engage in a conversation with someone who you think is dangerous. You can't have it both ways. Either you wanted to engage in this conversation, which would have been consensual if he wanted to have that conversation, or you stand down and you contact authorities, but you don't try to force a conversation and utilize this detention and excessive force. So I don't think that that should be the avenue. If I was if I was representing Mr. McMichael, I wouldn't make Mr. Arbery seem dangerous, that they just wanted to find out more information, because that just doesn't make any sense.
Katherine, what about the citizens arrest law that they had there? Now, it has since changed, but these defendants are going to be evaluated based on the law as it currently was at the time. Do you think the defense attorneys are going to make an argument that the reason it was changed was because of the Ahmaud Arbery case, and that that in fact that kind of proves that what they did as far as the citizens arrest piece was lawful?
Well, the law was changed because of what happened with Mr. Arbery, and the defense will try to use that, but I don't think that's going to be effective. I take issue with what Mr. Sheffield said in terms of that these are just well-intentioned individuals who are trying to prevent a crime. They were stating that there were multiple burglaries there, but supposedly there was only one burglary that happened there in that area, and that was a theft of a vehicle, of a gun, of an unlocked car. And also the citizens arrest law, as it was at the time of Arbery, of the killing of Arbery, stated that they must have reasonable and probable suspicion that Arbery was committing a felony. But if you see it at the preliminary hearing, where the lead investigator, Wiley, actually testified as to the timeline of the events, we cannot just isolate that one video that Brody took. We have to look at what happened, and it looked like the only thing that Michael saw was Arbery running or jogging across their property. And why would you have reasonable suspicion that he committed a crime by just jogging? Because he looked similar to a burglar before, but there's no evidence about that.
Yeah, very interesting analysis there. Also Linda Kenny Bodden had an opportunity to speak to the defense lawyer as to what kind of juror they're looking for, jury selection being so important. Let's take a listen.
We're looking for people who understand truly the concept of their duty and their responsibility as a juror. We're looking for people who may recognize that they've heard a lot about this case, that it's come from the media, that it's come from conversation in the community, but that they haven't actually heard the true facts of the case. And we're looking for them to recognize the difference between what they may hear in the media versus what they hear in the courtroom, and to promise us that pursuant to that duty and that responsibility that we all have towards our truth-seeking process, to the presumption of innocence, to the burden of proof on the prosecution, that they will come into this case with an open mind and not have any prejudgments about the guilt of the
You're
accused.
in Brunswick County. Is this a county that you deem good for us, given the fact that I watched this morning that none of the jurors felt they'd ever been discriminated against in terms of employment or in terms of arrests or anything of that sort? Do you think this is a good county for you, and why?
Well, it's Glenn County here down in Brunswick. And I was a little surprised at the lack of answers on that question myself. That's one of those questions where we know that it's true and that all jurors should be raising their hands, but none did. That then becomes part of what we have to do when we have the jurors individually, one-on-one, to begin to ask them to kind of reassess that a little bit and to talk and be open about race in the community or racism in the community and how it may play a role in the justice system and in policing. And so we're still following up on that particular question. But ultimately, I do believe out of all the jurors that we've summoned here, we will find 12 well-intentioned, well-meaning jurors who understand what it is to do their duty as a juror, and that we will have a few alternates as well.
We have some updates on some interesting things that are going on in the courtroom right now. Defendant Brian's attorney, Kevin Gow, requested that Arbery's family leave the courtroom, and the juror that was inside at the time was asked to leave. Gow brought up to the judge that Marcus Arbery, that's Ahmaud's father, and representatives from Transformative Justice Coalition were wearing lapel pins that have logos that could influence potential jurors. Their pins were had on them a quote from Representative John Lewis, famed civil rights leader, about "make good trouble," quote unquote. A pin with the logo from the Rainbow Coalition Social Justice from 1971 by the Reverend Jesse Jackson, "People United to Save Humanity." The judge will ask anyone who enters the gallery not to display their particular opinion, and he basically just left it at that. Travis McMichael's attorney, Bob Rubin, objected to the state referring to Arbery as a victim. Prosecutor changed her questioning and now refers to Arbery by his name. Kaysia, so we got a lot going on here in terms of trying to obviously have a fair and impartial juror. So what was your feeling about what the lawyer had said to Linda Kenny Bodden and these now latest developments of the judge telling people you cannot wear pins advocating for one side or the other when you're in front of the jury?
Well, I'm a strong believer that the voir dire or jury selection process is the most important process. That's your time to educate the jury and get that fair jury. And I, as a criminal defense attorney, I usually request that the prosecution not relay or call the victim. Usually the judge will allow it, or then I will educate the jury and let them know every time the prosecutor calls the victim as opposed to their name, you put a ledge in front of it because my client is innocent until proven guilty. You have not heard any facts or evidence in the case. So if the judge allows it, I take my time to educate the jury, but I do also agree with the judge's call to come in if you are a family of the victim. You can come in dressed, you can come in because you do have that right to be in the courtroom, but to make sure this entire proceeding is fair, although we do want justice, any shirts or masks or buttons that will have a message that can possibly sway the jury one way or the other, I agree with the judge to keep that out. That is not appropriate in the court of law.
Yeah, and we will say that race will come into play here. One black man wrote in his jury questionnaire, guilty. They killed him. He was struck for cause. And I'm sure we can expect that there's going to be a lot of that sentiment going on. Okay, we have more coming on with the Noor decision and the Noor case, which is going to be a very, very important decision as it relates to Derek Chauvin as well. We're going to be talking about that on the other end of the break. So please stay with us.
You did shoot across the nose of your partner. You did endanger a bicyclist and residents of a community of surrounding houses on a summer Saturday evening. One household was entertaining guests on a porch adjacent to the gunfire. These factors of endangering the public make your crime of manslaughter appropriate for high end of the guideline spots. I hereby sentence you to the Commissioner of Corrections for a period of 57 months.
All right, so there we are looking at the resentencing of Muhammad Moore. Why is this relevant? He was a Minneapolis police officer who was sentenced to many years in prison, convicted in April of 2019 of third-degree murder and the second-degree manslaughter in the 2017 shooting of Justin Roschik. Last month, the Supreme Court reversed that third-degree murder conviction, asked for this resentencing. That's why we're here. Katherine, I hear you have a specialty in this kind of area. This is a case that you're inspired by. Talk to us about what the meaning of this is as it relates to the Chauvin case, because this was a big issue that happened during the Chauvin case. And does that open up any appellate issues for Chauvin, given how the Supreme Court ruled in the Noor case?
Yes, it's very interesting as to the legal aspect of this, because the Minneapolis Supreme Court stated that the mental state required for a depraved mind cannot exist if the action is directed at a particular person. And because Noor directed his act of killing Roschnik, then that cannot be considered third-degree murder here, because the mental state is depraved mind. That's why the Supreme Court overturned it. So we have to remember that the Supreme Court overturned it, not because they did not think that Noor is not guilty. In fact, the Supreme Court stated, we believe he is culpable and should be sentenced accordingly. But the problem is that he was convicted of third-degree murder and not convicted of second-degree intentional murder. So that's the problem here. And the Supreme Court stated that, that he could have been charged with second-degree felony murder, but he was not. But I would say that, the law of depraved mind in that state has been unclear, and that's what the Supreme Court recognized. And it's interesting, in one of their footnotes in the opinion, and they stated that perhaps, they implied that perhaps it's time for the legislature to change that law to make it more specific, to give prosecutors and jurors guidance on what depraved mind really is, so that defendants can be charged accordingly. Now, in terms of your question about how this relates to Chauvin's trial, as we saw at his trial, he was initially charged with third-degree murder of depraved mind. And then the judge there struck that out, saying that, no, he was trying to commit an act against Floyd with particularity. But then the Court of Appeals issued a decision at that time that says, wait, that's when they reversed Noor's appeal and said, you don't have to need particularity. That's why in Chauvin's trial, that third-degree murder charge was reinstated. And so, as we know, Chauvin was convicted of third-degree murder, but he was also convicted of second-degree unintentional murder, and that's what he is charged and convicted. So there will be an appeal for taking that third-degree murder off.
Yeah, the trial judge in Chauvin was white, in other words, according to the Supreme Court. But the judge went by the appellate division. A lot of people said, wait, the Supreme Court resolves this issue because what the jury is charged is a huge thing. And now you've given the defense a huge, again, I go back as being a prosecutor. I would hold off until the Supreme Court ruled so that I don't have this matzo ball of an issue now in the Chauvin case. And now it's been teed up for that. Anyway, let's listen to the prosecutor in the Noor case argue why he should have received the maximum sentence.
Our reasons for asking for the number of 57 months and for that sentence, we believe that are several. One of them is that this case now stands alone among manslaughter cases in the state of Minnesota, second-degree manslaughter cases in Minnesota, on its facts. This will be the only time that a police officer has been sentenced for a crime under this offense in the state of Minnesota. And also, for those of us who practice in the area, we refer to things that are worse than typical or more serious than typical, which is always awkward when you're talking about the loss of a human life in a serious criminal offense. But nonetheless, that's how we do our work. And by every measure, the facts of this case, what the jury heard, what was decided by the jury, is worse than typical for a second-degree manslaughter case, all of which are very, very serious. One of the reasons that this case is more serious than others is because of the fact of who the defendant was at the time. He wore the badge of a Minneapolis police officer voluntarily and by his own statement with pride. That was something that he wanted to do, a job that he chose. And we learned during the trial, particularly from Chief Tim Longo from the University of Virginia, we learned about the social contract that exists when someone puts on that badge and what they have agreed to do. And that social contract provides to officers a privilege and rights to use deadly force to protect other civilians. And that is a privilege afforded to no other member of society in the United States. And the defendant had that privilege. The other side of that social contract belongs to the citizens. The citizens agree not to take matters into their own hands, and that when they see something dangerous or when they need help, that they will reach out to the police to get the help that they need. And we exist side by side that way.
Kaysia, I want to give you an opportunity to respond to this because maybe our audience may not understand, particularly if those who are not attorneys, why it's so important the judge gets the right jury charge down and the right charges and how that can impact the appellate courts, because the defense fought vociferously not to have that third-degree murder charge in there. So do you believe it has an impact, or do you believe the court's going to say, irrespective of that, he was found guilty of the other charges, so no harm, no foul?
No, this will definitely have an impact. A judge is definitely required to follow the law. And if the law is not followed, that is why we have the appellate court and the Supreme Court to have this checks and balance on the court itself. So it's definitely imperative that the judge follows the law and not the feelings. We're not trying to persuade a jury. So it is up to the judge to apply the law as to the appropriate charge and the appropriate punishment in this case. And I like how the prosecutor was basically persuading the judge to give the officer the maximum sentence. She talked about great power that this officer had, and great power comes great responsibility, and he failed to utilize that power in this particular case.
Yeah, definitely. I think that on both counts, that was a great speech by the prosecutor, and it's so true. And on the second count, again, another unforced error, in my opinion, as to why the prosecutor would not have waited for the Supreme Court to rule because the decision was imminent, but it didn't occur. Katherine, I'm told you're leaving us. It was great having you on the show. Thank you so much for coming. Great job. We're going to take a quick break on the Law and Crime Network, but we'll be right back. Please stay with us. You got it, Katherine.
So, we are right outside Capitol Reef right now in a free dispersed camp spot, and we've been lucky so far at all the places we've stayed, but I'd say this is one of the best so far. Since we left New York, I've only set up my hammock once, and now we're all the way in Utah, and luckily enough, I was able to set up my hammock in one of these trees.
And we're kind of like in the desert.
Very few trees.
All right, welcome back to Law and Crimes for the Record. My name is Bob Bianchi. These are the updates on the Brian Laundrie search. So human remains have been recovered in an area close to where Brian Laundrie's car was last parked in the reserve. Apparently, water had receded and those human remains were found, but also a backpack and paperwork that are already been identified as Brian Laundrie's. So the medical examiner is reviewing this. Interesting to me, the medical examiner is saying that they hope to have an ID within 1 to 2 days with a body must be severely decomposed in that particular environment that they're in. So that to me is an interesting sign. We had our very own Joseph Scott Morgan, who is a forensic death investigator, give us information because it's not just about the identification of Brian Laundrie, if in fact that is him, but it's also about the cause and manner of death. Let's take a listen.
You start talking about items. So what are those items? Could it be clothing, backpack? Could it be bones? You never know. And then the fact that they had the parents out there, maybe it was a specific item they wanted them to physically identify. Say, does this belong to your son? Have you ever seen him with this item in his hand? And of course, they're not going to bring the family over if they have skeletal remains or remains in any other condition to see the body there. That's Hollywood myth. That doesn't happen. They're going to keep them away. This is a closed crime scene at this point. The other thing that you have to consider here is the Emmy is there. And I worked for the Emmy for a long time in Atlanta and with the coroner's office just outside of Atlanta, outside of New Orleans, started my career. I can tell you this, we never showed up unless we were invited, all right? And for us to be invited means that you found human remains. And it's a long process. People, listen, please listen to me. Folks have to be patient with this because this is not even like Gabby's case, because if these are his remains and they've been down for, say, for instance, as long as Gabby's were or approximating that period of time, these remains are going to be significantly decomposed. It's in a harsh environment. It's going to take a while to put these pieces together. And thirdly, they brought cadaver dog out there, allegedly, according to reports. So what that would mean to me, and this happens, and I'm sorry, I'm going to be a little bit graphic here, so just bear with me. If someone finds remains, okay, maybe you find the central portion of a skeleton, let's say spine or ribs and this sort of thing. What generally happens is that over a period of time, due to animal activity, scavenger activity, remains become disarticulated. And animals will take these remains and they will wander off with them. Generally, they don't go very, very far, but you have scattered remains that are all around. And you have to kind of connect this, and let me explain why. The dogs would go out and hit on any other remain that might be out there. You know, just think of a wagon wheel hub and the spokes going out from it. They'd have to take this and kind of bring it back to that central collection point. Do you remember they showed that tent being set up out there today? That's going to probably be the central collection point where they're going to, gather everything. Now, they're not going to try to, if it is a skeleton, they're not going to try to re-articulate the skeleton out there. This is going to go back to the lab. There's a high probability it could go to the CA Pound lab at University of Florida. It's a human remains identification location. But at any rate, you have very little evidence to go on. You don't know what brought about that's what makes skeletal remains so difficult. You don't know what brought about the death. So you have to collect everything that is there, consolidate it, examine it in a controlled environment, and it takes days, sometimes weeks, to make these kinds of determinations. And sometimes you're not even going to know because all you have left is a skeleton. If you don't have a skull that has a bullet hole in it, or if you don't have soft tissue where you can appreciate strangulation or hanging or something like that, sometimes, you know, the forensic community is just left to say, best guess here is undetermined. We can't come up with anything solid. And I know that's going to leave a lot of people dissatisfied, but I'm not saying that's what's going to happen, but just prepare yourself for that because it does happen on occasion.
We actually have a statement from Steve Bertolino, who is the Laundrie family attorney, that yesterday he gave to the Law and Crime Network, and I'd like to read it to you. Chris and Roberta Laundrie were at the reserve earlier today when human remains and some of Brian's possessions were located in an area where they had initially advised law enforcement that Brian may be. Chris and Roberta will wait for forensic identification of the human remains before making any additional comments. We have Julie Rendelman with us, former district attorney, criminal defense lawyer, and law and crime analyst, along with Kaysia, who's been with me for the ride from the beginning. So welcome to the party, Julie Rendelman. So I want to ask you your thoughts. I found it interesting. Look, both of us were former homicide prosecutors, that they're thinking of making an ID within 1 or 2 days with a body that clearly is going to be significantly, you need entomologists and stuff like that. The only way in my mind they could do that is with DNA matching. And secondarily, the parents were at that reserve. Do you think that they've already preliminarily made the conclusion that this is Brian Laundrie?
If I remember, I could have sworn there was another statement made by the attorney where he actually said that the remains were in fact Brian Laundrie. So it seemed to me that he had some indication that it was in fact him, whether it be clothing that they found him wearing or that he's so close to the site of the items that were clearly Brian's that they're assuming. It's kind of unusual. I think you know, and I know that it usually takes a bit of time to process this, but they seem to want to get this done. This was a manhunt that, you know, took up tons of resources. And my assumption is that they're rushing to find out if, in fact, it is him.
Well, you know, I'm getting something new from our producers right now, which is interesting, Kaysia. It says something that we should be adding is from News Nation at Brian Entin, E-N-T-I-N, new. The medical examiner says he does not expect to have an identification of the remains today. Again, I get back to the speed. We've done these investigations, and we take a long time. And sometimes in these conditions, it can take a very long time. So he's not saying it won't be tomorrow, but it won't be today. The alacrity or quickness with which this is happening says to me that they know pretty definitively, but they have to wait for the official conclusion from the medical examiner. Thoughts?
Absolutely. You can just put the 2 and 2 together that they found it near his clothing and that the parents also assisted. The parents initially told the FBI that that was one of the points that Brian Laundrie would frequent. And there has been reports that there was water. The water has since receded. So, I mean, if you put all the circumstantial evidence together, I mean, one would likely assume that this is the body. But of course, they want to give a definitive statement. And obviously, we do have to wait. I was kind of surprised if they did come back with the testing earlier than 2 days from now. But as we can conclude, I suspect that this is the body of Mr. Brian Laundrie.
Right. So the medical Dr. Brent Blue, who is a coroner, has performed the autopsy on Gabby Petito's body. He's declared this an act of domestic violence. Let's listen to a little bit of what was said there.
Well, it was quite the media circus and continues to be. Unfortunately, this is only one of many deaths around the country of people who are involved in domestic violence. And it's unfortunate that these other deaths do not get as much coverage as this one. I'm assuming that because the deceased was a blogger, that this received more coverage than others. But there are a lot of both men and women who have lost their lives that aren't covered with this kind of media attention.
Julie, I don't know what to make of this, and I don't know. When I was prosecutor, I never allowed anyone other than myself to do press conferences in cases because it can lead to bad public information, can poison investigations. But you know, they need to be careful to dot I's and cross T's about whether this is a domestic violence, whether Brian Laundrie is the person that did it. this investigation, there were two people that were murdered in close proximity, weeks before all of that. So, jumping to these conclusions right now, I'm not saying it's not him. I understand he's a person of interest. I understand today's domestic violence is tomorrow's murder, but it is good prosecutorial technique to wait and close all the gaps, dot I's, cross T's, look for third parties, by the way, who may have been involved in this in some way, shape, or form before making comments like that. What do you think?
So I think, am I missing something? Isn't this the same medical examiner that when asked if, in fact, Brian Laundrie was involved in this, stated that I can't tell you whether or not he's involved or not. My only job is to let you know what the cause of death is. And so if the only job is to, am I missing something? Isn't that the same medical examiner, was I looking at this incorrectly?
Julie, this is the problem that I had, and I don't know if you had it as well. I mean, we have to wait for their determination on cause and manner of death. But I have been involved in a number of cases where without the right investigative information, they say, we're independent, stay away from us, don't tell us what to do. And they're calling things medical events and accidents that later turn out to be homicides, and they're calling things that could be homicides. This is a big problem across the country. And I understand as a prosecutor, my job is not to interfere with the independent nature of it, but there were too many mistakes that were being made. You are 110% correct that he said he couldn't do it. And now all of a sudden it seems that he's saying that there's a connective tissue here. That's why he shouldn't be speaking. Kaysia, what are your thoughts?
I absolutely agree. I mean, this was definitely, I was shaking my head. This was definitely the same medical examiner when asked the question as to whether or not this had any connection to do with a domestic violence. He said no. And I do agree that he should remain independent, examine the body, present your evidence, because this could definitely hurt the prosecution if this was not Brian Laundrie's body and remains. This could possibly hurt because the defense attorney can attack whether or not this was whether or not there's a bias in his testimony or any accuracy or lack thereof. So I definitely agree. Do your job, stick to it, leave any legal conclusion to the experts so that you won't tarnish the investigation.
Well, one thing we learned today with respect to this coroner is don't mess with Rendelman because she's on it. She's got this down. She's going to know what's going on with every permutation. So it gives us a good time to take a break, though. We're going to be coming back with more of Nikolas Cruz and some of the strangeness of what went on in that courtroom. He pled guilty to all of those murders, but it doesn't end there. There's still a penalty phase. We'll be right back.
Counts 1 through 17 of the indictment charge you with murder in the first degree. These are life felonies. They are punishable, they're capital felonies, and they are punishable by one of two ways, either life in prison or the death penalty. Do you understand?
Yes, ma'am.
Do you understand that in Florida, life in prison does not carry parole like other states?
I understand.
Do you understand that life in prison means the term of your life? It means you will not come out until you are no longer alive. Do you understand?
Yes, ma'am.
And have you gone over that with your lawyers?
I have.
And do you understand that that is the minimum penalty on counts 1 through 17? In other words, that is the best case scenario for you as a term of the rest of your life in Florida State Prison. Do you understand?
Yes, ma'am.
And do you understand the maximum penalty is death?
Yes, ma'am.
Do you understand that that issue will be left to a jury to decide in a separate trial?
Yes, I do understand.
Do you understand, has anyone made you any promises or guarantees as to what sentence would be imposed if you were to plead to the charges 1 through 17 of murder in the first degree?
No, ma'am.
And when I ask you if anyone's made you any promises or guarantees, I mean your own lawyers as well. Have they made you any promises or guarantees as to what sentence would be imposed, whether it be life or death on counts 1 through 17 by you pleading here today?
No, ma'am.
Now, sir, this is what we would refer to as a strategy decision. In other words,
there he is, Nikolas Cruz, pleading guilty to the murder of 17 people from the Marjorie Stoneman Douglas High School back in February of 2018. Jury selection for the penalty phase will begin on January 4th, hopefully with testimony being taken by January 14th of 2022. This was really quite an extraordinary development. He also pled guilty to another case that was pending against him previously. It was supposed to start before this case. So all of those matters are over with, other than will the jury give him life or will they give him death? Let's listen to the lead prosecutor as they lay out the factual basis which must be given before a defendant can plead guilty in order for the judge to accept the plea.
Upon entering the east doors of the 1200 building, Nicholas Cruz turned right and walked into the east stairwell of the 1200 building. He then proceeded to take out his rifle from the rifle bag and loaded it with one of the magazines. As the defendant was loading the magazine into his rifle, a student walked into the east stairwell, and the defendant said to him, "You better get out of here. Something bad is about to happen." The defendant then entered the hallway at approximately 2:21:33, and he fired his rifle at 4 students who were in the hallway. 3 of the students were in front of classroom 1215 on the south side of the hallway. Gina Montalto was sitting outside the classroom of 1215 working on her computer. Martin Duque Aquillano and Luke Hoyer were standing next to her, knocking on the classroom door to gain entrance. Ashley Baez was further west, walking down the hallway towards the west doors. The defendant fired his rifle at Gina Montalto, Martin Duque Aquillano, and Luke Hoyer. They were all shot. Ashley Baez was shot in the leg, but she managed to run to classroom 1210 across the hall. Ashley Baez survived her wounds. The defendant then turned and fired into the classroom window door of classroom 1216 on the north side of the hallway. He then knelt down in the hallway, took off his backpack, pulled out his tactical vest, put the vest on, loaded another magazine, and he crossed the hallway to the south side of the hallway once again to classroom 1215 and 1214, which are both adjoining classrooms. He again fired into Gina Montalto, Martin Duque Aquillano, and Luke Hoyer. Gina Montalto, 14 years old, who was sitting in the hallway in front of classroom 1215, was shot 4 times and died of her wounds. Martin Duque Aquillano, 14 years old, was shot 8 times and he died of his wounds. Luke Hoyer, 15 years old, was shot twice and he died of his wounds. The defendant then began firing through the glass window again into 1214. Then he went across the hall, placed another firearm magazine in his rifle, returned to 1214 and fired once again into classroom 1214. 6 of the students in classroom 1214 were shot. Helena Ramsey, 17 years old, was shot 4 times and she died of her wounds. Nicholas Dorette, 17 years old, was shot 3 times, and Nicholas died of his wounds. Isabel Checker, Danielle Menescule, Samantha Grady, Samantha Fuentes were wounded, but they survived their wounds. The defendant then walked east in the hallway and once again fired through the classroom window door of classroom 1216. He shot 8 students in classroom 1216. Alex Schachter, 14 years old, was shot twice and he died of his wounds. Elena Petty, 14 years old, was shot 4 times and she died of her wounds. Alessa Alfadeth was shot 8 times and she died of her wounds. William Olson, Justin Colton, Genesis Valentin, Alexander Dorette, and Kashab Magaporium were wounded, but they survived their wounds. The defendant went back across again to 1214 and he fired into 1214 once again. As he was doing that, Coach Christopher Hickson opened the west doors of the first floor hallway and ran in to see what was happening. The defendant fired his rifle at Christopher Hickson, hitting him twice. Christopher Hickson, wounded, crawled across the hallway and hid in one of the alcoves on the north side of the hallway. The defendant then walked up to classroom 1213 on the north side of the first floor hallway and fired through the glass door in the glass in the classroom door. Carmen Shentrup, 16 years old, was shot 3 times and she died of her wounds. Madeline Wilford was shot multiple times, but she survived. Samantha Mayer was shot multiple times. She survived. And Benjamin Wickander was shot multiple times, but he survived. The defendant then continued west down the first floor hallway, and as he passed Christopher Hickson, who was hiding in the alcove, he fired once again into Christopher Hickson. Coach Hickson was shot 3 times, and he died of his wounds. The defendant then entered the west stairwell, and as he entered the west stairwell, there is a door to the west stairwell. And coming in through the door in the west stairwell, which was Coach Aaron Feist. As Coach Aaron Feist opened the door, the defendant fired twice into Coach Feist, who fell by the west stairwell door. Coach Feist died of his wounds. The defendant then went up the west stairwell and entered the second floor hallway. As he went down the hallway, he fired into classroom 1231, which was empty, which was on the north side of the hallway. He then crossed the hallway and fired to classroom 1234. So on the south side of the hallway, that classroom was also empty. He then walked up to the east stairwell, and he walked up the stairs. Due to the percussion from the defendant firing his rifle, the dust from the ceiling tiles caused the fire alarm system to sense smoke, causing the fire alarm to sound. Because the fire alarm was sounding, the students and the teachers were evacuating their classrooms due to the fire alarm sounding. The defendant, upon reaching the third floor, as he exited the stairwell, he fired into Scott Beagle, who was a classroom teacher in 1256. Scott Beagle was shot 4 times, and Scott Beagle died of his wounds. The defendant then fired at another teacher, Stacy Lapel, who was out in the hallway with Scott Beagle. She was wounded, but she survived her wounds. She was a classroom teacher in classroom 1255. As the students and teachers were running back to their classrooms, the defendant placed another magazine into his rifle and proceeded to fire. He shot Meadow Pollock, who was hiding in an alcove of classroom 1249, along with Carol Longren, as they hid in that alcove. The defendant then shot down the hall Anthony Borges multiple times. Anthony Borges survived his wounds. Marion Kabachenko was shot, but he survived his wounds. Kyle Lehman was shot, and he survived his wound. The defendant continued to fire as he moved down the hallway, shooting Meadow Pollock, Carol Longren, Joaquim Oliver Padoy, Peter Wang, and Jamie Guttenberg. The defendant continued further west in the hallway, and as he approached Meadow Pollock and Carol Longren, who were still in the hallway, lying on the floor in the alcove of 1249, fired into them once again. Meadow Pollock, 18 years old, was shot 6 times, and she died of her wounds. Carol Longren, 14 years old, was shot 3 times and died of her wounds. The defendant then approached the alcove of the men's bathroom on the north side of the hall. Lying wounded on the floor in front of the men's bathroom door was Joaquim Oliver Padoy. The defendant once again fired into Joaquim Oliver Padoy. Joaquim Oliver Padoy was 17 years old. He was shot 4 times, and he died of his wounds. The defendant then approached Peter Wang, who was wounded and laying just outside the hallway of the west stairwell. Peter Wang was 14 years old. He was shot 12 times, and he died of his wounds. Jamie Guttenberg, 14 years old, as she was running down the hall, she was able to reach the door on the west side of the hallway. She was shot, and she died of her wounds.
Wow, Kaysia, I got to be honest with you. I mean, the prosecutor's recitation, with all of that activity that was going on, to be able to piece it together in a timeline in the way they did, that is not easy, folks. That is a lot of forensic evidence, and to show where he moved, how he moved, what he did next was really, really impressive. In light of that, Kaysia, we talked about this before. Is it possible that he pled guilty, the defendant, to all of these murders so as not only to accept responsibility, we talked about that before, but will certain evidence now not come out in the death penalty, in the penalty phase of the case, that would have come out in the guilt phase, like much of what this prosecutor just talked about? Maybe limitation on autopsy photos and gruesome details and things of that nature. Or in Florida, will the prosecution be able to get all that information in your mind out before the jury in the penalty phase?
Well, the penalty phase will certainly be a trial, albeit a mini trial. The prosecutors are going to do everything in their power to get as much information out before the jury. And I will tell you one thing about this prosecutor. He has been married to this case from the very beginning. Nicholas Cruz, from his initial arrest, he wanted to plead guilty, but the death penalty was never taken off of the table. So this prosecutor really wanted to get across to the judge that very specific, calculated of his events line by line. And if you think that this prosecutor's description of what happened was impactful, wait until the victim impact statement. I don't believe that the jury will not be emotionally affected. Just hearing that, I just got chills all over again because I was in the courthouse when we heard that there was a school shooting. I mean, this has impacted the entire community. And I just don't know how this will be mitigation at all with them taking this plea.
Yeah, Julie, as a defense lawyer, would you at least be making an argument in the penalty phase right now that, hey, Judge, we don't need to get into the graphicness of the photos and the autopsy pictures and all the bad stuff. And tactically, if the jury doesn't see that, at least it takes a little, maybe not a lot, but I'm sure that those photos are extremely graphic. So do you think this is a way to limit the evidence in the penalty phase?
Yeah, I mean, I think it's two things. I think, the one thing that it's very hard as a defense attorney in a state that allows for the death penalty to switch gears, to basically argue to a jury, first of all, either someone's didn't do it or they didn't do it because of mental disease or defect, or they did it, but because of mental disease or defect, they're not responsible. It's very hard then to lose and then switch gears and go, ignore what I said before, but let's talk now differently about my client. And so this kind of avoids that, having a jury kind of look at a defense attorney and not really believe in them. And so what they're allowed to do now is say he took responsibility. He did it because he was trying to alleviate the family of sitting through this trial. And now let's focus on the issue at hand, which is what is the mitigation? It also prevents the cross-examination. I'm betting you that the defense attorneys during much of this are not going to cross-examine anybody in regards to anything unless it relates to mitigation.
Yeah, they're just going to be putting on a mitigation piece. I would agree with that, and excellent analysis by both of you guys. Well, Markeith Loyd, another case for the murder of Lieutenant Debra Clayton, is on a trial right now, possibly facing a death sentence. It's the second time Law and Crime will be covering one of his cases, gavel to gavel. We'll have more about that on the other end of the break, so please stay with us.
Out of all the gifts I got, this is one of the best, or I have received, this is one of the best. Because I always hugged her in her uniform, even before she went to work, while she was on duty, because we were that close. We talked every day, every hour. So it's like, seeing this patch, feeling it again, I thought I'd never be able to feel it. It's just amazing. I'm very thankful for it, to Megan. It's amazing, I love it, I really do.
That is Lieutenant Debra Clayton's son holding up a bear that is received from his mother. Obviously, very, very dramatic and sad occurrence here. So Markeith Loyd is on trial again. In the first trial, he was accused of and convicted of killing his ex-pregnant girlfriend. The jury had come back with a life sentence as opposed to giving him the death penalty. He was on 27 days on the run when somebody spotted him at a Walmart and alerted the lieutenant. The lieutenant actually approached him and made an apprehension, but called in for backup. And it was at that point in time that the lieutenant was shot and killed. This is a death penalty case, as I have indicated. We hope that jury selection will be over. It's anticipated by the end of next week. But, jury selection is not easy. And making decisions on executing people is not easy. And getting jurors who are not afraid to be part of the process is not easy. Let's take a listen to one of those jurors.
Good afternoon. How are you?
Good.
No, I don't know. It's a little strange being in this situation, I'm sure.
Yes, I was in Pine Hills that day, and I was under, lockdown when the roads were closed, so it's been, a rough weekend.
Your voice is shaking, and you're near tears.
Yeah.
Let me just get
all
to
weekend.
it. Have you formed an opinion on Mr. Loyd's guilt? What is it?
Guilty and death penalty.
Okay. State?
Speak moves, Your
All right, this isn't the case for you. Good luck,
I'm
Tina.
sorry.
You're free to
Sorry,
go. You don't need to
it's better
apologize.
judgment. Thank you.
Okay, so these are the stats that we have so far. They have 55 jurors and moving to the final round next week. They were hoping to get 60 jurors in order to be qualified before the lawyers go into what they call peremptory challenges. The judge is calling another small panel of 40 more jurors, and they will try to get 5 qualified from there. And there will be a motion hearing tomorrow at 1:30. Julie, this gets to the point when when I've picked the death penalty jurors, it's very emotional. I mean, they understand the nature of what they're being asked to do. And some of them are scared, like, for example, individuals who are living in the community when this happened that went into lockdown. And so everybody knows about this case. How do you pick a fair and impartial jury under those kind of circumstances? And is that why this is taking so long?
Look, it's funny, the juror that just spoke, I mean, obviously that's not a juror that you want on if you're the defense attorney, you don't want them, as a juror, but at the same time, you're happy to hear them telling the truth. And I think she was pretty clear and confident with her answers. I don't think she was just doing it so she could get off. And so I think, she symbolizes in many ways as a defense attorney and a prosecutor what you want from the other jurors. You may have an opinion that people don't like. You may have an opinion that you think makes you look bad, but that is what we demand, as defense attorneys and prosecutors and the judge in order to be able to, present our client, present the case in a fair and just manner. We don't know who the heck we're getting on these jury panels. We have to pray every time that when they speak, they're being truthful to us. We find out all the time that they've lied. We find out all the time that they have an agenda. That's what social media has come to be in terms of that. But we hope that we're picking a fair and impartial jury, but who the heck knows?
Yeah, Kaysia, I just want to add to the point, because this is something that's going around the country and it's happening right now in New Jersey. I actually serve on a committee for the New Jersey State Bar Association where they're either trying to eliminate peremptory challenge or significantly reduce peremptory challenges. Apparently, this has occurred in other states as well, and this seems to be the flavor of the day. Talk to us about the importance of what Julie just said. There could be a million reasons you want to remove somebody. There have been times where judges put a juror on and don't remove them for cause, where both the prosecutor and the defense are saying this juror should not be on. What kind of system of justice can we look at if we no longer have peremptory challenges so that our clients as defense lawyers can have a voice, and our clients as the state, that is the people of that particular state, have a voice in who they select as their jurors?
Well, we definitely want to keep the scales of justice equal. Peremptory challenges are absolutely necessary. And as long as you can give a race-neutral reason as to why you're striking that potential witness, it's all game. As long as it's equal on both sides, I've utilized peremptory challenges to what I call is jury deselection. You want to get rid of those potential jurors that give you the answers, but you can read between the lines that this potential juror is not right for you. You can judge the body language if they're not giving you the right language, which is very important. I always say that jury selection is absolutely the most important part of a trial. So getting rid of a peremptory challenge and just leaving the 4-clause challenges, that is a horrible idea and will be very detrimental to the case.
Real quick, yes or no? Have you ever been in a scenario where the person's saying that they have a bias and prejudice, or they otherwise wouldn't sit there, and you get the judge that says, do you mean to tell me that if I tell you to be fair and impartial and that you're to listen to the facts and the law, that you would not follow my instruction? And the juror kind of quakes a little bit, says, oh, no, I could do that. The judge says, okay, that juror's good. Has that ever happened to you, Julie Rendelman?
All the time. You knew the answer.
And Kaysia, does it happen to you all the time?
All the time. I always say you can't rehabilitate once they give you your answer.
Yeah, yet those judges will keep those jurors on. Anyway, let's listen to another prospective juror who literally broke down when being asked questions about this case.
Good afternoon. How are you?
I'm good. How are you?
I'm fine, thank you. I know this can be a little intimidating and nerve-wracking. Try to relax, okay? I'm going to be asking you some questions. You okay? You're tearing up. What's wrong?
I just feel very uncomfortable being in the same room. I'm sorry.
Being in the same room with us or with Mr. Loyd?
Mr. Loyd.
Okay. Any objections?
No, Your Honor.
All right, ma'am, you're free to go. Thank you very much.
I'm sorry.
It's all right. No need to apologize.
Yeah, I mean, it's again very emotional. So a part of this defense in this case is going to be insanity, Julie Rendelman. So what are you thinking from put your prosecutor hat, defense hat on as to an insanity defense on this case, given the actions of the defendant both during and after the encounter with the lieutenant?
Looking at his actions both during, before, and after. And so to me, the shooting of this officer was based on one reason: to get away with the other crime. That is not the acts of someone who is acting only on the impulse of a mental disease or defect. It's someone that seems to know what they're doing and knows it's wrong. So look, I don't want to get ahead of myself. We haven't heard the evidence. We haven't heard what his mental disease or defect is. So maybe it will overcome the prosecutor's position. That I don't know.
Yeah, and Kaysia, going back to that peremptory challenge issue again, there are a lot of people who may not be as emotive, but we've all, I'm sure, been in the courtroom where the juror answers all the questions right or whatever, and then goes back to that jury box and like turns and looks at either the lawyer or the defendant in a way you're like, yikes, I don't like the feel of that. So this juror was very honest, but we also have the other problem in cases like this. There are people who want to be on the jury and know intellectually how to say all the right answers because they have ulterior motives in fame and being able to write a book and so on and so forth. What are your thoughts about all of those issues?
Yeah, I mean, you don't want the extremists, right? I mean, it's good that you want to serve your civic duty, but at the same time, is there an ulterior motive, just like you said? So it's up to the lawyers, again, to ask those questions to make sure that you will get a question or a response that will elicit, to give you the opportunity to utilize your peremptory challenge. As long as it's race neutral, you can ask that person a scale of 1 to 10. That typically works for me because, again, if they're giving you all 10s down the road, that could be a red flag as well.
Well, let me ask you just quick yes or no. Do you buy the argument that it would save time if we just ended peremptory challenges and we've got lots of cases and we need to move them forward? Is that a legitimate argument when it comes at the cost of due process, Kaysia?
Absolutely not.
Julie?
Absolutely not. Couldn't
Julie.
agree with her more. Couldn't agree more.
Okay, guys. Yeah, thank you very much. Okay, guys, we have a lot more on the plate. Ahmaud Arbery is going to be next. So we got some developments that are going on with that case, another horrific case, arguments happening in court with respect to various things that are occurring inside the courtroom. We're going to talk about that and more on the other end. Stay with us.
Stated on the crime scene that was overheard by one of the defendants and shared with investigators prior to police arriving, correct?
That's correct, yes, sir.
And though this may be an uncomfortable conversation for the benefit of the court and for the record, we're making it clear that this is not your quote, it's not the GBI's quote. This is a quote from a statement of Mr. Bryan as to what he heard Travis McMichael say prior to police arriving, correct?
Very much so, yes, sir.
Understanding that and understanding that it might be a little uncomfortable to talk about the words because it involves a curse word and something else, I need to ask you about that quote. Can you please articulate for the court what Mr. Bryan said he heard Travis McMichael say prior to police arriving and after the fatal shooting?
Yes, Mr. Bryan said that after the shooting took place, before police arrival, while Mr. Arbery was on the ground, that he heard Travis McMichael make the statement, fucking.
All right, that was a GBI investigator pretrial hearing describing what Travis McMichaels had said. And now they're doing a lot with juror selection here. We have over 1,000 prospective jurors that have been summoned to court so far. There are a total of 15 jurors that have been qualified, and they're looking for that magic number of around 64. Our very own Linda Kenny Bodden actually had an interview with Travis McMichael's lawyer, Jason Sheffield, on what people are calling Trayvon Martin, the Trayvon Martin defense. Let's take a listen.
Yeah, I would not put this case in the same category as Trayvon Martin, but this case is about a crossroads. It is about a crossroads where the law of citizens' arrest meets self-defense. And at that crossroad, we know that there are going to be very difficult issues for the jurors to work through. Citizens arrest law, as it existed back in 2020, is somewhat of a difficult law to understand, but when you apply it and you really do get down to its essence, it becomes very simple, really dealing with the concept of probable cause. What did the person believe that the suspect was doing? And then in the lawful execution of that arrest or detention, did things reach the level that they became dangerous, life-threatening on the person seeking to detain? And in this case, we say absolutely. And so that's ultimately what we have to help the jurors understand. The question will be, are they brave enough to do their duty and find these defendants not guilty? That is something that we're still working through.
Julie, I know as a prosecutor, when I would prepare cases, I would think about what is the defense going to be doing? What is their strategy? So number one, once again, we talk about our 15 minutes of fame. We get up there giving the prosecution all sorts of preliminary data that the prosecutor can now prepare for because we don't know. So that's great. Prosecutors keeping quiet. They're talking about what the defense is. And in addition to that, you're talking about 3 men in a truck pursuing an individual on foot with a firearm that are recording it. And do I understand the defense lawyer to be saying that in that particular situation, they may have been in fear of their lives and needed to shoot this individual twice? Is that the defense here?
I don't think so. I think he's talking about the nuances of citizen's arrest. Keep in mind, the law has changed since this case, and it is. I think we've both read it, and it is a little bit confusing, I must say. Which, by the way, I think inures to the benefit of the defense in this case. The problem is that anytime we talk about self-defense or we talk about what happened here in terms of probable cause, quote unquote, is we can't look at the case in a vacuum. There's steps that were taken. So maybe one could argue they were allowed to follow him. Maybe they were allowed to chase him. I'm not saying they were, but how do you get from that to killing him? That's the problem. Exactly. And so that's what the prosecutor's going to do is they're going to break down each part of what happened. And the fact that it resulted in a death indicates perhaps that they weren't just committing a citizen's arrest and they were doing much more than that.
Yeah, I mean, I agree. We have to take everything in the totality of circumstances. That citizen's arrest law, Kaysia, if I were a defense attorney, I'd be arguing they had to change it because they knew what was done here was lawful and they didn't want it to happen again. But no matter how you add it up, you still got 3 people, whether doing a lawful citizen's arrest or not, who are there with en masse, physically big guys against one individual, and they have a truck, which is a weapon in and of itself, cutting him off, and a shotgun. But somehow I'm trying to get to the part in my head, maybe you could explain it to me, as to how the defense is saying that he needed to be shot twice because you certainly just can't shoot him because you're arresting him. You have to be under some sort of self-defense scenario. Where is it?
And that's exactly the turning point is when Ahmaud Arbery reached for his gun. The defense strategy is that he was overpowered. So the initial citizen's arrest now blossomed into self-defense. And that can be construed if you look at the video. But the problem, again, arises that you continued to pursue him. You knew that he did not want to engage in a conversation. So at what point should you have disengaged or backed down and contact the authorities? So he was already, just like you said, he was already outnumbered with the 3 against 1. And then they also had the ability to follow him with the vehicle, and he was on foot. So could they have backed down to prevent this from happening? And that's where the prosecution is going to argue.
Yeah, Julie, in a hypothetical scenario as a prosecutor, let's say I'm in summation. I could be thinking about an idea where I say something to the effect that let's give the defendant every benefit of the doubt. That he was committing a crime, that they were pursuing him lawfully under the citizen's arrest law as it existed at the time. They had a weapon with him, but they bring that weapon out. And the fact that he made Ahmaud Arbery grab the weapon and or defend himself when he has a shotgun, that's where you can never justify the use of deadly force because it was them employing the deadly force and he was defending himself from that. What do you think about that argument?
But then you have a problem, because then how do you, as a prosecutor, prosecute the other two individuals? Because then the moment in time is simply that you've separated. If the jury accepts that this was a citizen's arrest, then arguably these three people had a right to chase him and had a right to commit that false imprisonment that we're talking about. And so the problem with the prosecutors, if they were to argue that, if they were to say, even if you accept this to be true, that moment when he fires the weapon, this is what happens, that's really just between Travis McMichael and Ahmaud Arbery. And so therefore you're saying find him guilty, but then what do you do with the other two defendants in that scenario?
Well, Kaysia, real quick, I think there's going to be a problem with regard to potentially that in any event in this case, because their involvement is much more removed from actually the person that shot. Who shot the person? So what do you think?
Accessory.
Yeah, real quick, Kaysia.
Accessory. So although there was one person who was responsible for committing the fatal blow, they were all involved and they all acted in concert.
Okay. All right, guys. Well, we'll see how this is going to play out. Certainly going to be some interesting tactics by the lawyers in this case. I think with respect to those two that didn't shoot, you may see a different kind of presentation of the case than you will for Travis. Kaysia, great job. I know you got to go, but we're going to be coming back with more with Laundry. Stay with us.
They're going to be in an advanced state of decomposition. I would imagine that there might be some soft tissue left, but you're going to have a lot of skeletonization that has gone on, not to mention any kind of animal involvement. So it's going to be it's a daunting task for the scientists that are involved in this case to try to, make a determination. First off, the ID is the most essential thing. You can't really move forward beyond that. You have to determine scientifically, this isn't something you can just go out and look at it with the unaided eye. You have to scientifically confirm it. We all want that, because this is a type of case that if you don't scientifically confirm it, it's going to come back to bite you. So you do it through dental, if there's dental available at the scene, and of course we can do it scientifically also through DNA. So I think there's a high probability we'll get them identified.
That was Joseph Scott Morgan, forensic death investigator, speaking to the Law and Crime Network, based on the discovery that the FBI confirmed yesterday that they found human remains as well as Brian Laundrie's notes and backpack at a location that had been under water, but the water had receded and those items became evident. We're finding out right now from News Nation reporter Brian Entin, E-N-T-I-N, that, and I'm quoting, "We have learned the remains found in the Carlton Reserve were skeletal remains, bones." Okay, so that is a new development that we have right now. So this is obviously a very, very important thing. Keep in mind, the coroner has indicated that they're going to come back with a determination within a day or two, although we found out today it will not be today. But the coroner doesn't seem to think they're going to be taking a long time in order to make that identification, which I think we can draw some conclusions from. Let's look at an interview that Chris Cuomo did, an exclusive phone interview with the Laundrie family attorney, Steve Berlino.
Absolutely. And, now's not the right time to talk about, the situation with Gabby, but the family was following my directions. I told them not to talk to anybody, not to say a word. I was the intermediary between the family and law enforcement. And that's why we're confident that, law enforcement, specifically the FBI, was informed. Brian did not come home that night. Whatever played out in those 3 days after that, that's on the police and the FBI. That's not on the family.
We have Julie Rendelman with us, who is a law and crime analyst, and now Andrew Scott, who is a trial attorney. Andrew, let me toss this to you first. This attorney has come under a considerable amount of fire for telling the Laundrie family to remain silent and not to cooperate, essentially, with law enforcement. Do you find that that is in any way unethical behavior and or advice that any criminal defense lawyer would give in a situation like this?
It's absolutely not unethical behavior. In fact, it's the right advice in this situation. They should not be talking to law enforcement. They should not be essentially discussing anything with them that might implicate themselves in any sort of crime, because it's obvious here that you have a lot of people that are looking to get vengeance or justice in this type of situation. And as an attorney, it's their job to protect their client. If they're retained, it's their job. In fact, I would think it would be malpractice not to do that.
Yeah, Julie, why is this attorney coming under such fierce and, fiery criticism from all media outlets, conservative and liberal, with regard to advice that, I listened to somebody who is supposedly an expert talk about what an outrage it was and no defense lawyer would ever do something like this. I can't even believe what I'm listening to when I hear these things.
I don't know. Maybe they're not that knowledgeable. Any one of us knows that if we had a client that was, by the way, not even the suspect, maybe just a witness, my natural inclination would be don't speak unless I tell you to. And so in this case, of course, the advice would have been not to speak to the police. There are some nuances to this, though, subtle nuances. And I say that because there might, I'm not saying there was, I don't know everything. There might have been ways to help the investigation. I don't know if they did. For example, there are ways to kind of insinuate where perhaps Gabby Petito might have been left without the defendant, without Brian Laundrie, without his family ever speaking to the police and protecting them, if especially there was some belief that she might be alive. So there are little tiny nuances that I can see an attorney finding a way to help. But in general, there is absolutely no reason that an attorney would ever let their client speak. And by the way, he's right. It's his fault, not theirs.
Yeah, so let's listen to a little bit more of this Chris Cuomo interview, because it's pretty fascinating as the lawyer is trying to explain to the world why it is he gave the advice he gave.
So can you help us understand how an area that the authorities were told about, you say, by the parents that isn't even that deep into the preserve, wasn't located all these weeks with all the dogs and the teams and everything else until the parents showed up?
Well, listen, the explanation that the FBI gave today certainly makes sense. If that area was underwater, one can certainly understand why you might not have been able to find the items that were located today. If that water had cleared, 2 weeks ago, perhaps could have circled back and looked again. Perhaps they meant to. Perhaps they were further deeper into the park and never got back to this park because it is so near the entrance. Chris and Roberta went to this area first, and as happenstance was, they stumbled upon these items.
All right, so Julie, any more from that explanation? The parents helping out, bringing them possibly to a location that their son may have camped at before, but the items were underwater. Does that lead you to the conclusion that they were covering something up in your mind?
Necessarily. Again, we have to assume that the attorney's being honest and forthright when he says that the family told them where to go prior to this and that they just couldn't locate that area. It is it is a little weird that it's the day that the family goes out there that suddenly this is found. But, I'm not going to draw conclusions. I am curious exactly what law enforcement would say that the lawyer or the family told them in the days prior to establish that this was the specific area and whether they were detailed and where they should go.
How about you, Andrew? Do you find anything odd about that? And does it lead you to the conclusion they may have covered this up, the parents?
Well, what are they supposedly covering up here? We have such bloodthirsty vengeance on behalf of so many people in the public that they're losing the fact that these parents just lost their son and just found out that their son is likely dead. Were they supposedly covering up where their son's body was? That doesn't make sense to me. So, no, I don't think it's strange at all. And as you said, when this story that the parents, started assisting the investigation and they found some of his materials and some body materials, people trying to act like there's some sort of weird connection there. I don't see it, especially now that it's come out that this area was underwater and now it's not underwater.
Yeah, let's listen to a little bit more of this interview where the lawyer is questioned about how the backpack actually got there.
What do you make of the suggestion that Mr. Laundrie planted the bag and the backpack?
In nice terms, it's hogwash.
Would the authorities have known what they walked onto the trail with?
Absolutely. They met them at the gate or somewhere nearby. They walked in with them. And more importantly, Chris, this is what I said. Fortunately for the Laundries, the press was following them in the whole time.
Andrew, I guess if we're going to follow that theory, then we would have to explain how it is that human bones and human remains were also found at that location. Thoughts?
Yeah, I mean, obviously, Mr. Laundrie also didn't plant the human remains there, you know? So, I mean, it just seems like so many people are looking for a reason to blame any of the Laundries in this type of cases. They're not realizing that, you know, what very likely happened here is after Brian Laundrie went and disappeared, he very likely committed suicide. And, you know, I think it's pretty obvious that that's what happened here.
Julie, what do you think about that? I mean, cause a matter of death may be difficult in a situation like that with decomposition in the state in which the body was found. But do you think it's? I know it's hard for you to speculate, but is it an accident? Was it animals? Was it suicide? I mean, I really love to see what those notes are and what's in that if it's retained, if they can read it.
Yeah, I think Andrew might be right. It seems like it may be a suicide. I have to take, I have to question one thing he said is when we talk about the cover up the family, the cover up isn't covering up Brian Laundrie being dead. It's covering up for Brian being alive, meaning that Brian is fleeing or Brian is not wanting to be caught and the family's not saying where he is. So I don't think the argument is that they were covering up knowing that Brian was dead. I think the argument is they were covering up thinking he was alive and they didn't want him to be caught. I'm not saying that's true, but I'm saying that's what the theory is about the cover up.
Yeah, and Andrew, so that they had every reason, the parents, to find Brian Laundrie because they were concerned for his safety and actually alerted law enforcement authorities with respect to that. But as far as charging the parents with aiding and abetting, I'm confident I read a statute in Florida that makes that very, very difficult to do. Are you familiar with that law?
I'm not familiar with the Florida statute. I do often find that aiding and abetting charges are pretty hard to prove, especially beyond a reasonable doubt. I mean, basically at this point, they would have to prove that the Laundries knew that Brian had committed this crime. And I don't understand how you prove that with Brian no longer with us, like it appears he isn't.
Yeah, and Julie, at the after the fact cover-up, as they're referring to, like they maybe weren't involved actually in the murder of Gabby Petito, but they may have after the fact been covering up. It is very difficult to prove those cases in most jurisdictions. I believe there's a Florida law that specifically protects them, but that's all the more reason why you don't have them speak, especially when they're being blasted in the media, because any statement that they may possibly give, I'm not defending them, I'm just telling you how, as a prosecutor, I would think a defense attorney would act, as a defense attorney, how I would act. They could make a completely innocent statement that turns out to be inaccurate, and then somebody could sit there and say, you see, you're lying to police and covering up the investigation, it could become charged.
Bob, we see this all the time. Every time a client opens their mouth, they say something that's, by the way, often innocuous, and somehow it's spun around in a way that makes them look guilty of the most horrid of crimes. That's why we tell them to keep quiet and shut their mouth. So, yeah, I mean, you know, and by the way, it's usually the most meaningless little thing, whether they were wearing red or white, that can come out that makes it, this is the smoking gun. So yeah, the parents had every right not to speak. It was their child that had disappeared. And by the way, the Florida law does seem to prevent, at least in this situation, a parent being charged when it comes to their child.
Yeah, it's my understanding of the law as well. And let's never forget that the United States Supreme Court justice who wrote and has carried through all of our law that the Fifth Amendment right to remain silent protects the innocent as well as the guilty. And on that note, we're going to take a short break, but we're going to be coming back with Mohammed Noor. You may recall this case is important as it relates to Derek Chauvin. We'll break it down on the other end of the break. Please stay with us.
Your Honor, I just want to say that I'm deeply grateful for Mr. Damon's forgiveness. I'm deeply sorry for the pain that I've caused that family, and I will take his advice and be a unifier. Thank you.
You did shoot across the nose of your partner. You did endanger a bicyclist and residents of a community of surrounding houses on a summer Saturday evening. One household was entertaining guests on a porch adjacent to the gunfire. These factors of endangering the public make your crime of manslaughter appropriate for high end of the guideline spots. I hereby sentence you to the Commissioner of Corrections for a period of 57 months.
Okay, Mohammed Noor resentenced. Let's break this down as to why this is important with regard to Derek Chauvin. Noor was a Minneapolis police officer who was convicted of third-degree murder and second-degree manslaughter. He had received a 12-and-a-half-year sentence. Now, as you remember, we were talking about this case a lot during the Derek Chauvin case because the appellate division was considering whether or not the third-degree murder charge should have survived based upon the way the statute reads. The argument bled into the Chauvin case, the defense arguing it should not be charged in the Chauvin case because it wasn't done with, quote, particularity. Rather, it was towards one person. That would be Mr. Floyd. And that therefore it was not with a depraved mind pursuant to that statute. And the judge in the Chauvin case actually had ruled that way and agreed with the defense until the appellate division came up with a ruling that contradicted that. There was a discussion that they should wait till the Supreme Court could decide this issue, but the judge and the prosecutor decided to move forward. Well, now we know the answer to that decision, and the Supreme Court has said, no, Noor's actions were directed with particularity towards a person, not others. The sentence was reduced from 12-and-a-half years to 5 years, of which he's already served 2.5 years. Julie Rendelman, this is a big issue in my mind on appeal in the Derek Chauvin case because the defense argued this point vociferously, and the audience needs to understand that jury charges are the sole responsibility of the court, and this court, that court expressed its reluctance, and if I recall, was actually ordered by the appellate division to change the decision to throw out the third-degree murder charge against Chauvin, and then it got brought back into the case. Explain to our audience why that is so important that now we know the Derek Chauvin jury charge was wrong.
So, well, we know the Noor jury charge was wrong. Now the question is it wrong for Chauvin? Is there any difference in terms of the facts? I mean, we think of depraved indifference usually as that scenario when a person shoots into a crowd and ends up hitting someone. We don't think of it in the Noor situation or in the Chauvin situation where the assault is occurring in regards to one particular person. In Noor, it was the young woman who he shot, and in Chauvin, it's George Floyd. And so, look, I thought the judge had it right initially because I thought Noor was not going to get through, and it didn't. And now we have a conviction for that. And so if it falls, that means the conviction falls, which changes everything with regards to Derek Chauvin.
Yeah, why prosecutors would not have used the rule of reason and just waited till the Supreme Court could rule so that they had not create a great appellate issue like this, who knows? But let's listen to a little bit more of this resentencing.
I last saw you on July 7th, 2019, 2 years, 3.5 months ago, and certainly much has changed in the world since then. But I need to read a portion of what I said on that day, because the jurors in this case, citizens of Minneapolis, raised questions then that remain unanswered. On July 7th, I said, the primary concern of the jurors who heard the testimony in this case when I spoke with them after the verdict was, will there be changes? Change is needed. Will some of these supervising officers be fired or disciplined? Is what we saw normal for the Minneapolis Police Department and the Bureau of Criminal Apprehension? How will this be prevented from happening again? Why are officers more concerned about their personal safety than the safety of the public, especially in such a low-crime neighborhood? Why should a civilian have to be afraid of approaching a squad car? What about the motto on the car door? to serve with compassion. Why were Mr. Noor and Mr. Harity so reactive? What was their training? The jurors in this case were particularly concerned with Officer Harity's statement that his priority was making sure he did whatever he had to get home safe each night. Jurors remarked that they thought the priority of the police was supposed to be to protect and serve the public. No one who heard the testimony in this case or who works in the criminal justice system can question the difficulty of a patrol officer's job or the dedication of the majority of the police and first responders. But here, something went very much awry. The victim's family and some of the witnesses, including some officers, have expressed concerns. A large amount of taxpayer dollars will go to Australia, but Minneapolis residents await the promised transformation, and the questions of the jurors remain unanswered. What has changed? What will change so that this does not happen again? How does the department address officer safety without jeopardizing public safety? The jurors and the people of Minneapolis need and deserve answers. The citizens of Minneapolis have now paid out $47 million in settlements for allegations of police negligence and malfeasance. Since we last met, another person has died at the hands of police after two other rookies responded together in a squad to a low-risk situation which escalated. The community exploded. Another police officer has been on trial for murder. Mr. Noor, I am not surprised that you have been a model prisoner. However, I do not know of any authority that would make that grounds for reducing your sentence. There was no departure motion in this case by either side, and so no departure from the guidelines is appropriate or legal. You have been convicted of manslaughter in the second degree, culpable negligence, creating an unreasonable risk of harm. As Ms. Sweezy said, the court may sentence you to between 41 months and 57 months. That is the range.
So that sentence goes down to 5 years. He's already served 2.5 years, so half the sentence. I'd really love to know the parole eligibility guidelines in that state to see if there's even a possibility he may get out even sooner than that. I guess we could look into that. Julie Rendelman, they talk about what's going on in Minneapolis, the police department. I was big when we were covering Gavel to Gavel, the Derek Chauvin trial, and I was shocked that the defense attorney did not pull out Ben Crump, the attorney, the civil attorney for the family, who wrote an amazing complaint, an amazing civil complaint, demonstrating the policies of the department, the procedures of the department, and how the higher-ups knew that these things were happening, the number of people that had chokeholds placed on them or neck restraints that were hospitalized. It was an extremely detailed picture that this was the custom, practice, and policy of the Minneapolis Police Department. That's fancy language under 42 U.S.C. 1983 civil rights law. And then during the Derek Chauvin case, those very same administrators who are responsible for making sure that their officers are temperamentally fit and that they're properly trained and that they're not doing things that are a violation of the policies got up and pointed the finger at Derek Chauvin. I was just thinking to myself, as a defense lawyer, I could just see myself being in a courtroom saying, you know who should be sitting in that chair as a defendant? Those guys that took the witness stand in the criminal case, the CYA. Those are the individuals. So what do you think about all that? Ben Crump's statements are essentially parroting what this judge is saying about criminal justice reform at the Minneapolis Police Department.
So two things I'm going to say. I think the judge gave a great speech. However, this is about Noor and what his responsibility is in this specific case. It's not a judgment on the entire police department, and shouldn't be. It's about him and whether there's mitigation regarding him and only him. With regards to Ben Crump and Chauvin, I'm not sure that would have been effective. And the reason is that I agree with you that there were policies in place, and there's still policies in place that create a scenario of which these things can happen. But I think anyone, look, I hate to go, I'm going to go back there to the minutes upon minutes upon minutes that Derek Chauvin had that knee to his neck. And there's no policy that's ever supported that I remember. And so maybe it would be effective with the other defendants when they go on trial. But Derek Chauvin, I'm not sure any juror would have bought it.
Well, yeah, maybe not, but I'm talking about from the policy point of view about criminal justice reform, Andrew. The internal affairs process has to work properly, and you have to ensure that officers are doing things by the book, or if the book needs to change the book. It just seems that they were, they're kind of a creation of the culture those very higher ups who came up and testified against Chauvin are a part of. But just a sidebar for a minute. How does this change in the third-degree murder charge for Noor affect Chauvin's appeal, especially when the jury came back with higher-level convictions? Does the appellate court look at it and say, look, it shouldn't have been charged, it was inappropriate to have been charged, but the jury found much greater conduct, throw out the third degree, leave the rest?
I think that's one thing that the appellate court could do, and I think that's the cleanest way they can handle this type of case. I mean, as I recall, that Chauvin trial went on for months, and I don't really think that anyone really wants to have that case remanded and have the trial go back on. So I think the cleanest thing the appellate court could do is throw out that third-degree murder charge and adjust the sentencing accordingly based on the higher degree charge there. But again, it comes back to the prosecutors in this type of case. They knew that there was this issue out there lurking, and for whatever reason, they didn't show the restraint in saying either, okay, let's wait and see what happens with this appeal so we know what to do, or what might have been even more prudent was just avoid this charge and just move on with the other charges because they were going to win on them anyway.
Yeah, well, they wanted them there for a reason. They wanted them there as a backstop should they have a problem proving the other charges, in my mind. But anyway, we're going to take a quick break here, but don't go anywhere because Nicholas Cruz pled guilty, but he still has a sentencing phase to determine whether he will live or die. Some of the parents of the victims' reactions coming up next.
Okay, Mr. Cruz, I'm going to go over each charge with you and ask you how you wish to plea in these matters. Now, if you don't have any questions.
I do not have any questions.
All right, to count one of the indictment, murder in the first degree of victim Luke Hoyer, how do you wish to plead?
Guilty.
To count two of the indictment, murder in the first degree of Martin Duque Anchiano, how do you wish to plead?
Guilty.
Count three of the indictment, murder in the first degree of Gina Montalto, how do you wish to plead?
Guilty.
Count four of the indictment, murder in the first degree of Alexander Schachter, how do you wish to plead?
Guilty.
Count five of the information, murder in the first degree of Elena Petty, how do you wish to plead?
Guilty.
Count six of the indictment, murder in the first degree of Alyssa Al-Hadef, how do you wish to plead?
Guilty.
Count seven of the indictment, the murder in the first degree of Nicholas Dorette, how do you wish to plead?
Guilty.
Count eight, murder in the first degree of Helena Ramsey, how do you wish to plead?
Guilty.
Count nine, murder in the first degree of Christopher Hickson, how do you wish to plead?
Guilty.
Count 10, murder in the first degree of Carmen Shentrup, how do you wish to plead?
Guilty.
All right, Nicholas Cruz pleading guilty to 17 counts. So let's understand what went on here. A trial was set for him to have both a death penalty case, but you have the guilt phase first, and then you have the penalty phase should the jury find that you committed a capital murder. He has pled guilty now, so that phase, the first phase, is over. He's going to go directly to his sentencing phase, which will be before a jury, where they will make a determination as to whether or not he should live or die. But you can only imagine how difficult it was for those parents to sit inside of a courtroom, watch the man or the young man that killed their children pleading guilty to these offenses. I could tell you firsthand experience, there's so many mixed emotions that they have with all of these kinds of things, including the fact that the child is no longer around. So we had some reactions from some of the parents, including the mother, Jenna Hoyer, who is Luke Hoyer, one of the victims in the case, who was 15 years old, giving a little statement about what they were going through after listening to this plea of guilty. Let's go to it.
My son Luke Hoyer was 15 and miss him dearly. He should be here today, and we're just still in shock. We're glad today has come this way, and we're hoping for accountability of the death penalty.
Initially, Cruz pleaded not guilty, but now he's changed it to guilty. How do you feel about that change?
I think it's a strategic move by the defense team, totally, and they're trying their best to keep a violent, evil person off death row.
And what was it like when he said, "I'm sorry and I love you," to hear those words from the killer?
That was useless. To me, they're going to try to use any words he used today in his defense to not get the death penalty.
And what have these last 3 years been like without your son? I mean, I can only imagine.
It's been hard. Luke was my third child. He was my surprise baby. And I always used to say, because he was so funny and cute, we would laugh. And I go, what would we ever do without him? He wasn't planned. And now I have to live those words. I do have to live my life without him. But I know he's with me. I know he's on my shoulder. I know he's with God. And I miss him terribly. He was a sweet young man that had a life ahead of him. And the person you saw in there today chose to take his life. And he does not deserve life in prison. Life in prison is a life. And he deserves nothing more than the death penalty.
And what was it like to hear the prosecutor describe step by step how he went through the classrooms and the building?
You know, we live that every day, so it's hard to hear, but it's needed. We know what's needed to get a conviction or a death penalty. So we're willing to sit through it. Even if I have to sit through trial, I'll sit through 100 days in there if we get the results and accountability.
Are you planning to be at every hearing?
I don't know yet.
Could you tell us about your necklace?
This is Luke is my favorite picture. My co-worker. I work at SOS Children's Villages in Coconut Creek, and my co-worker gave it to me yesterday. So I wore it. I wear a picture of him every day, but this one's very special. So I wore it today.
No, I don't think there's closure to this. This is not something that you ever get over. It's just something that you learn to live with. And, we think that, who knows? Maybe someday we find rooms in our heart to forgive him, but that's not the same thing as extending mercy. And I don't think this killer deserves any mercy. So I think that whatever happens to him happens, but it's something we live with for the rest of our lives. There's not going to be any closure.
He had this weird thing where he said, "Where I have to live with this every day." Did that strike you as what did you make of that?
Self-centered. Thinking about himself.
Just goes to show that's all he thinks about. I mean, the murders, he planned this out. He thought about it. He researched, the school. It was very calculated. He deserves no mercy at all. He walked onto a campus, was not encountered, and he got to accomplish his goal of killing people. And it is my biggest wish that he cannot complete his second goal of avoiding death penalty.
Andrew, another interesting permutation of this case was that Cruz actually said to the court that he preferred that the victims make the decision as to whether he should live or die. That caused the court to say, well, no, that's not the way the law works. He said he understood it. Nevertheless, he believed the victims should and the parents should be the ones that make the decision. Probably wouldn't be a good idea. He indicates he wants to live, but based on what we're hearing from those two parents, I'd imagine that's the sentiment of most of the parents. And if the victims were to decide this, that would pretty much be the end of Nicholas Cruz. He would get the death penalty. So tell us, what are your thoughts about that? And why don't we have a system of justice where the victims make the decision as opposed to a jury?
Well, first of all, his entire statement was written and approved by his attorney. So that's what you have to realize. So everything that's being put forward right now is not in any way to appease any of the victims or any of the parents of the victims of this situation. He's going to the court. He's going into the press. He's trying to get to anyone who'll listen, that trying to show that he has some sort of remorse over this incredibly heinous crime. And the idea that the victims should choose what he wants to happen to him is, it's kind of the thing that you almost kind of have to smirk at as an attorney, because everybody knows that when one of the main aspects of criminal law is it's when you commit a crime, it is a crime against the people of the state. It's a crime against society. So society gets to choose, what happens, and your district attorney here is the person who's representing the people of the state. So they're the ones seeking justice. Now you ask, well, why don't the victims of certain crimes get the punishment? Well, there's a lot of constitutional issues with that first part, but you could see that if that were the way it would go, there's a lot of type of people who would choose some very barbaric sentences for some very not so serious crimes. You might have your neighbor mad at you for, I don't know, knocking over his mailbox, and he might decide you deserve 20 years in prison. You can see how that could be a big problem. In this type of case, I think it's pretty obvious that the victims of this crime probably want him to have the death penalty, probably overwhelmingly, imagining what they had to go through. And I really think the statement is just something to toss out there to kind of show that he's remorse, which I actually don't believe. I don't believe he's remorseful. I don't know how you commit this crime and then try to go in front of a bunch of people a few years later and act like you have remorse over this.
Yeah. So we have more parents' reactions here, even up to and including, what can we do to stop these school shootings? Let's listen to the parents of victim Gina Matalto.
Well, it was a very difficult day. We've had to relive the murder of our beautiful and forever 14-year-old daughter, Gina. Mr. Satz had to state the facts in order to lay the groundwork for the penalty phase, but it's never easy to hear.
What was the most difficult part of today's hearing to hear for you?
I think the absolutely ridiculous statement from the defendant.
What did you find most ridiculous about it?
He's doing it for our families. If you wanted to do something for our families, you shouldn't have killed our loved ones.
What was it like to be in the same room with your daughter's killer?
Was probably the most uncomfortable thing, second most uncomfortable thing we've ever had to do. First one would be hugging our daughter's lifeless body.
And to have to relive this trial, these facts today, that must have been so difficult. How have these last 3 years been? How have you been able to cope and to move on?
There's no moving on. There's moving around. The pain that we feel every day. The loss of our daughter affects my wife, myself, and our son, and our entire family. And I'll dare say even our entire community on a daily basis as we all deal with this. So we just do the best we can to get through each day. But each day is very, very painful. Some days like today are especially painful.
What, if anything, is justice?
Well, I think that as a society, we should want people who commit heinous acts like mass shootings to be prosecuted to the fullest extent of the law. We need to find a way to prevent people from wanting to copy these things. We need the media to help us by reducing the notoriety that these shooters get. We need to prevent them from being idols to others. We need to always remember the victims and who they were, the bright and vibrant people. And finally, we need all Americans to come together and help us stop school shootings. If you see something, say something. If you have a suspicion, report it to somebody. We need to be proactive and prevent any other families from suffering the loss that we have of our beautiful, forever 14-year-old daughter, Gina Rose.
Julie, Julie, curious on your thoughts, having been a homicide prosecutor, how do we get there? How do we stop this gun violence, in particular school shootings?
If I knew that, I would, I think I'd be getting quite a lot of attention from everyone. I don't have the answers. I think, I think several things he said are true. The first thing is that whole see something, say something. I think in many of the school shootings, we come to realize that prior to the shooting, there were people that were aware of what was potentially going to happen and didn't notify anyone. Or they notified someone and no one did anything about it. So we have that situation. We also have the situation about having guns in people's hands with mental health issues, people underage, people who should be never anywhere near a gun. That's a whole other political argument that we could have for days. I can't tell you what the exact answer is, but I'm pretty confident that if you don't have a gun in your home, it is going to probably be a little more difficult to take a gun from your home and fire up an entire school. So, but again, I think much clearly needs to be done as this doesn't seem to end.
Yeah, it all comes down to one word for me, and I know nobody's going to pay either me or you to help out with the answer to this. Politics is the reason we cannot stop this. We're going to take a quick break. Markeith Loyd is up next. Stay with us. We'll be right back. Markeith Loyd was on the run for 27 days after killing his ex-girlfriend who was pregnant and had an encounter at a Walmart with Lieutenant Debra Clayton after a citizen called and said, "I believe this is the person you're looking for." An encounter ensued. The lieutenant was shot and killed. Markeith Loyd is now on his second trial. The first one was a life sentence, but now he's facing the death penalty. Jury selection, obviously, in a case like this can be very difficult. And we have listened to a number of jurors that have had difficulty with judges trying to get a qualified jury so that from there they can start using peremptory challenges in order to pick the jurors that will actually hear the evidence in the case. Let's listen to one of the jurors who made it through the round of questioning, a lawyer who has served as on 2 other trials as a juror, interestingly.
The judge asked you if you had any religious or moral objection to the death penalty. And correct me if I'm wrong, but when you said, "I do not," it appeared to be kind of a hesitation or a clip in your voice. Would that be fair?
That is fair.
Why? What comes to mind?
I think what I said in the response to the next question, I believe that Mr. Williams asked me, was what I was debating whether that was an answer to that question, because I don't have a religious objection to the death penalty. And my moral objection is more based upon those other factors that I think that, I've mentioned that the prejudice that in deciding which people get charged with the death penalty, which ones don't, troubles me. Then there's the economic realities that, perhaps our civil justice system would be better off if we just never used it because of how much smoother and cheaper and easier these cases would be, but there are those cases that make me think otherwise. And so you asked the question, that's all of that was in my mind at the same time, and I paused before I responded.
In order for a just verdict to be returned in this case, all 12 jurors' individual moral assessments have to be reflected in this courtroom and on the verdict form.
I get that.
And you are certainly not going to bully or badger another juror to agree with you.
That's fair, and I think that's a concern when you have a legal professional on the jury that they could try to utilize their knowledge to intimidate or change the minds of others, and I would be acutely aware of that and work hard not to have that occur.
Right. I think that's fair. It is a possibility that other jurors would look to you for guidance once they knew you were a lawyer.
All right.
And still, though, your opinion, while valuable, is not any more valuable than any other juror's individual moral assessments as to whether or not Mr. Loyd lives or dies.
That is correct. I'd say I think I followed that rule, that I kind of self-imposed rule that I just said in my other 2 jury experiences. I didn't get to actually deliberate on either, but even during our being in the sequestered room, that I made sure, people would sometimes ask me questions, and I might say, just general procedure issues, but I would purposefully never try to guide them on anything with the case.
All right, Julie, I got to go to you. Former homicide prosecutor. Okay, I don't know about you, but I never wanted a lawyer on a jury or a judge on a jury because he could say all the words he wants about how he doesn't want to overwhelm them. That's not even the point. The point is that people will naturally gravitate to him when they have the law, they have to go over the law. And so that gives that juror a lot of power in that jury room. I don't care what words he says there. However, he gave answers that were very favorable in my mind for the defense. So is that a juror? Is Julie Rendelman defense lawyer? Does that juror get on? Are you happy about that?
I don't know. I mean, look, I hear you about the attorneys. I have allowed attorneys on if they were willing to serve. He seems incredibly thoughtful in his answers, and so. And you are looking for that. You're not looking for someone who's going to necessarily appease either side, but someone who really is thoughtful with their decision making. And so the question is, by the way, if all the jurors are going to turn to him, is he someone I want them to turn to? Now, obviously, we don't know what his decision is going to be, but it might not always be a bad thing if someone that you respect and think that they can make the right decision and are careful about that decision, then I'm not sure an attorney is always the worst thing.
How about you, Andrew? If you're a defense lawyer, do you want this juror?
I gotta say, you better be sure if you're putting him on his jury that he's gonna fight for your client. I mean, the problem with having another attorney, and you see this all the time. I see this all the time. Every attorney always has their own opinion about everything, and they think they're 100% right. Okay. And I've got news for you: that whole jury is gonna turn to him.
Got it. You're absolutely correct, guys. I'm gonna have to end it there. I greatly appreciate both of your experiences. I certainly wouldn't want that juror on. Don't want to take the chance. That's it for me this week. I'll be back on Monday from 12 to 3, but do not go anywhere. Anjanette Levy is next. She'll be taking it over from here. You'll be in great, capable hands here. I hope you all have a great weekend. Be well, be safe.